witnesses?
In opposition.
All right. Good afternoon. It is 5:18. Thank you all very much. It's our second part of our bill hearings today for on April the 4th. When we last left our story, we were on Senate Bill 290, and I think we stopped in the middle of testimony right there. I think it was Mr. Kroll, and I think Ms. Smith, is that right? Or just Mr., well, apparently Mr. Kroll didn't get to say anything, so we're going to hear from Mr. Kroll. For 2 minutes, please.
Thank you, Mr. Chairman, members of the committee. Good afternoon. I'm Stephen Kroll, the Executive Director of the Maryland States Attorneys Association, the State's Attorney Coordinator, here in opposition and ask for an unfavorable report to Senate Bill 290. You've heard my testimony, and you've heard elected state's attorneys come here beforehand. Elected prosecutors are the more experienced trial attorneys that should be handling these cases. They answer to the voters. They're the ones who every 4 years have to go before the voters and say, we did this, this, this. If you don't like us, they could vote us out, not the Attorney General. We have more experience. We have better prosecutors who are used to doing these kind of cases. And quite candidly, if you look at the bill itself, especially on page 2, line 18, 19, 20, and 21, it says likely to result in the death. I have no idea what likely to result in the death would be in that definition. I have no idea, even under Maryland law, under first-degree assault, what serious bodily injury means. There's definitions in here that it will lead more courts to doing overtime work than anything else. And for all those reasons, I'd ask for an unfavorable report. If you still remember the testimonies of Senate Bill 290, I'm happy to answer any questions.
Questions, please. Delegate Erica.
Thank you, Mr. Chair. Thanks so much for being here, Mr. Kroll. I had an exchange with some of the FOP this morning. I'm not sure if you've seen any of the information coming out about some mishandling of a case in Prince George's County that's now coming back around. Apparently, one of the prosecutors that handled that case poorly is one that's running the department. Do you know about this situation?
I do not.
Okay.
I've not seen that letter.
Maybe that you could, I'll send it to you so you have a copy of it, but it's pretty disturbing. And so I think, obviously, if there's questions about the integrity of people that are running this office, then we have a much bigger problem. This bill might not be ready for prime time.
I'm just not familiar with it, so I can't comment on it.
Thank you.
Further questions? Delegate Kramer.
Actually, I have a question for Ms. Smith, if she is here. She's still? Okay, thank you.
Any further questions? Seeing none, we thank you very much, and that concludes the testimony for Senate Bill 290. We'll bring up the Vice Chair of Judicial Proceedings now. We'll start with Senate Bill 257, please. It's a task force bill.
Thank you, Mr. Chairman. It is indeed a task force bill. In recent years, Mr. Chairman, this body has made great strides towards ensuring that indigent Marylanders in our justice system are not forced to pay for the cost of their own incarceration or supervision. This body last year passed a bill to ensure that defendants are not forced to pay for their own GPS monitoring. We've also heard about the unfair system whereby indigent incarcerated Marylanders are required to pay exorbitant amounts for the ability to simply keep in touch with their family and loved ones. This is unfair. We don't bill prisoners for their food, for their library books, for their cots, for their plumbing, or for their hygienic items. Why do we bill them for basic phone calls? The current system has consequences for families and for reentry. Here's a quick staggering statistic. 34% of families, that's more than 1/3, go into debt in order to cover travel and phone expenses for incarcerated Marylanders. That's unacceptable, and it serves as collective punishment for family members who have done no wrong. In sum, encouraging incarcerated individuals to remain connected to their families and social networks is sound public policy. We want these individuals to successfully re-enter society upon completion of their sentences. The cost of a simple phone call should not be the reason that we fail in this objective. Senate Bill 257 establishes a task force to help us get to the point where we might provide no-cost prison phone calls in Maryland. I ask for a favorable report.
Questions for the senator on 257? Delegate Valentine.
Thank you, Mr. Chair.
And thank you, sir, for being here today. Is there a cap on the number of phone calls in this, or would this be just simply a call? Or I know for monitoring jail calls over the years, that can lead to dozens upon dozens of calls per day per individual. I was just trying to get a feel, or is this just the task force?
So it's just a task force, and this question came up on our side, and I think that is something appropriate for the task force to consider. As you probably know, prisoners are only allowed to make phone calls to a designated list of people that are approved, and so there is an inherent kind of limiting factor that creates, but not obviously an absolute limit in the amount of phone calls. So I think this task force will help explore that option, and the department is on the task force. And just so you know, this is only for prison phone calls. This is not for your local jail.
Okay.
This only applies to state prisons.
Questions? Seeing none, that concludes the testimony on Senate Bill 257. We'll go to 684 now, please.
Thank you, Mr. Chairman. With your permission, I have one witness on this bill.
That's fine.
Thank you so much, Mr. Chairman. Joining me for this bill is a woman named Giselle Merck, and Giselle's son was murdered 3 years ago in my legislative district. Ms. Merck registered as a victim so as to receive notification, as she is allowed to do under law, and one of the people who murdered her son was released from prison, from state prison, over the summer, and so she received a letter from Public Safety and Corrections. I'm going to summarize this letter and paraphrase it, but it basically says, the law requires us to send you a letter notifying you that this defendant is being released. If you have any questions or your safety feels threatened, call this 1-800 number to the Department of Corrections, and maybe possibly they'll consider helping you out. When Ms. Merck sent me the letter, I was deeply offended. I've provided this letter to counsel, and if you see it, I imagine you will feel the same. It does not provide resources that a victim can find actionable. Victims are human beings. The survivors of murders, like happened in Ms. Merck's case, are human beings, and they deserve the right to speak to a fellow human being who can help answer their questions. And so all this bill does is require these victim notifications to include the name of a person, the victim services coordinator in the jurisdiction where the prosecution took place. And that is it for Senate Bill 687. 684, excuse me.
Well, thank you all for taking the time. I am the daughter, sister, grandmother, and mother of gun violence survivors because of the assassination of my only son, J.C. Webster, on July 19th, 2017. My name is Giselle Merck. I'm here to shed some light on what I, as a victim, had to endure in hopes that you will vote in support of SB 684. The day after my hugger, J.C., was murdered, I threatened those involved on local news station. At one of the sentencings, the state prosecutor told me, if you want to change the outcome, you have to change the law. And that is why I am here before you all today. I'm here to carry out my son's quote of, I may not change the world, but I want to inspire many. Victims must suffer from the crime, write victims' statements, testify, endure courtroom drama, or be asked to leave. A victim attends parole hearings to fight for their loved ones, to make sure that those who committed the crime do the time. Victims can request to be placed on a victim's notification system. I am here because back in June of 2022, I received a 3-sentence note, not a letter, a 3-sentence note from the Department of Public Safety and Correctional Services informing me that the robber will be released in August. It reads, Dear Ms. Merck, we currently have a victim notification request from you on file advising us that you would like to be notified in advance of the reference inmate's actual release date. Please note that this letter is for notification purposes only. Please be advised that the above reference inmate is scheduled for mandatory supervision release on August 1st. Please notice how impersonal that note was to me, and that it consisted of 3 sentences. The second page informs me that the Department of Public Safety and Correctional Services will no longer be involved. If I feel my life is in danger, to contact local authorities as well as a few 1-800 numbers. JC has always been the one to defend people. I am here asking for justice for my son, JC, and justice for all victims by defending the victims, not traumatizing us with insensitive actions. What I have experienced is so impersonal. Where is the compassion? Where is the part of public safety in the Department of Public Safety? I see where the part of correctional services, but I don't see the Department of Public Safety. What is the definition of advance notice for a victim? There was no advance notice to the release of this individual to whom I threatened on the news. Imagine if I received such an impersonal note after I was raped, or at the hands of my domestic violence from my ex-husband. No, I received this note after the gun violence murder of my only son, J.C. Webster. How many other victims have received such an impersonal note? This month is the light of Jesus as Easter giving us hope. On the 23rd of this month, the Governor's Office of Crime Prevention will host its 33rd memorial services for crime victims and their families, where we will be able to just come together. I recently returned from a civil rights tour where one of the exhibits said, "Be the change you want to see in the world." I ask you to please support SB 684 and to help me carry out my son JC's quote of, "I may not change the world, but I want to inspire many." Please be a change agent here in Maryland to set the example for the world to see. Continue to shine God's light of hope into a world that is full of darkness. Thank you for your time, and I ask you to please be the light in this dark world by voting in favor of SB 684.
Thank you very much. Delegate Kaufman, please.
Thank you. And first of all, happy Passover to you, Senator Waldstreicher, and happy Easter to you, Ms. Merton. Great bill. And I'm so sorry for that unempathetic form letter that you received. Can you talk a little bit, Ms. Merton, about how the more expansive letter that Senator Waldstreicher proposes in his legislation would have helped you or brought you more comfort, and how you hope that it will help other people? In a sense, what I'm asking is, what is the benefit of the more expansive letter in your view?
The biggest benefit, showing compassion, showing that actually for the part of Department of Public Safety, you actually do care about mine and other victims' safety, that there is an individual that you can contact, not just some 3 sentences, not just, oh, okay, you threatened somebody, okay, contact your local authorities. Oh, and by the way, here's a list of numbers. How is that helping a victim? I've been victimized. So many of us have been victimized, and why do we then feel that we're victimized again?
Thank you, Ms. Merton. It's an honor to represent you along with Senator Waldstreicher.
Delegate Munoz.
Thank you, Mr. Chair. Thank you to the sponsor for bringing this incredibly important piece of legislation. Thank you, ma'am, for coming to testify today. My question for you, if you don't mind, is how long was the individual incarcerated between the time that you threatened them and the time you received this 3-sentence letter? And Senator,
Excuse me.
yeah, Senator, you're welcome to answer.
So this particular individual was apprehended the very next day that my son was assassinated. My son was assassinated on a Wednesday evening. This particular individual was apprehended at his job the very next day on a Thursday. There was no trial. It was a plea deal, so they did the sentencing. Let's see, JC, July will actually make 6 years that JC has been murdered, and this individual didn't quite serve 5 years. The system credited him for time being served, not realizing that in time being served, he did not turn himself in. The excellent detectives had to find him. So the system looks at how long the person has been apprehended. So for time served, the system looks at good behavior, which I could fake that if I wanted to. But the system looks at the good behavior. The system looks at so many things. But as a victim, we're treated as a victim. I hope that answers your question.
It does, thank you. So your son's life was taken, and the person who took his life spent less than 5 years in prison for that crime.
Yes, ma'am. The driver spent less time. The gunman is still serving, but this is why I'm here, because I don't want to have to come back here to find out that I have to go through this again for the gunman.
I hope you don't. I'm so sorry that our criminal justice system has failed you in so very many ways. Thank you for coming today.
Thank you.
Are there further questions? Seeing none, thank you all very much. Thank you very much indeed for coming here today. That concludes the testimony on Senate Bill 684. We're going to go now to Senate Bill 37 and Senator Waldstreicher.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, and thank you for accommodating Ms. Merck, and thank you for your time, and to the senators behind me for their time as well. I'm sorry. Senate Bill 37 involves expungement. I don't need to make an argument to this committee about why expungement is important. We are in possession of Delegate Valentine's bill on that exact topic, which you already heard and have sent over. 8 years ago, Mr. Chairman, under your leadership and the leadership of the current United States Attorney for the District of Maryland, we passed the Justice Reinvestment Act, which was enthusiastically signed by Governor Hogan and passed in a bipartisan manner. Now 7 years old, that time allows us to evaluate how our expungement waiting periods compare to the waiting periods in other states. And what we find, unfortunately, is that Maryland has longer expungement waiting periods than almost every other state. Indeed, 42 states have shorter waiting periods for misdemeanor expungement, including deep red states like Texas, Alabama, Mississippi, and Utah. And unlike other states, the waiting period in Maryland kicks in after the offender has completed their entire sentence, parole, probation, drug treatment, and any mandatory supervision. There's nothing wrong with that as policy, but in practice, unfortunately, it can create unintentionally absurd results, because in most instances, the waiting periods are far longer than the actual sentences. The REDEEM Act seeks to bring us into the mainstream of where other states are with expungement waiting periods. It does not affect the offenses that are expungible. That stays exactly the same. It doesn't remove any, it doesn't add any. It only affects the length of the waiting period. As amended by the Senate, it takes nonviolent felonies from 15 years down to 7 years. And it takes misdemeanors down from 10 years to 5 years. It does not affect domestically related offenses, which remain at a 15-year waiting period. After discussion with the committee, certain burglaries and thefts were slotted in between at a 10-year waiting period. This is an important bill and is an appropriate follow-up to what we did in justice reinvestment. For those who were here, I want to thank you, Mr. Chairman, for your leadership on that bill, Mr. Vice Chair as well, and ask for a favorable report on Senate Bill 37.
Are there questions for Senator Waldstreicher? Seeing none, thank you very much.
Thank you, Mr. Chairman.
There's one person testifying in opposition, Steve Kroll. We'll hear from him for 2 minutes, please.
Mr. Chairman, I think we have one person signed up. It's not sponsor only. We have a proponent signed up.
I see one person signed up in person in favor, and that's you. I don't see anybody else signed up to testify in favor.
I will defer to you, Mr. Dews from the Job Opportunities.
Mr. Dews wants to come up for 2 minutes. That's fine.
Christopher Dews, Job Opportunities Task Force. I know you all are already very much familiar with the issue. Delegate Bartlett did a phenomenal job with the hearing. Just want to highlight the importance of this. 25% of Marylanders have a criminal record that can be used against them when it comes to trying to secure housing, employment, education, all the rest of the things. I know it's going to be a very long night for you all. I just want to just highlight the importance of this and that this passed out of the Senate unanimously. Again, just a friendly reminder, misdemeanors at 5 years, the nonviolent felonies at 7, theft and first-degree burglary at 10. That was an agreement that was associated with the state's attorney's office. And lastly, I think second-degree assault and common law battery is down from 15 to 7 as well. It's simply looking at, again, after an individual has completed their entire sentence, parole, and probation, we just want to ensure that, that the state does not get in the way of individuals having a chance for reentry and to move on with their lives. With that being said, I guess I'll just end by saying me too.
Seeing none, thank you very much. Now we'll hear from Mr. Kroll for 2 minutes, please.
Mr. Chairman, members of the committee, good evening. My name is Stephen Kroll, the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association, here in opposition for an unfavorable report to Senate Bill 37. We are for second chances. We are for second chances. In fact, we believe that shielding is the way to go instead of expunging. Shield all the records that are on there, and it'll be more effective from there. Let me explain to you what we mean by second chances. In most jurisdictions in Maryland, in many cases that are on the docket, a first-time offender will get probation before judgment. A second offender will most likely get a suspended sentence, and not until the third time will that person be incarcerated by any stretch of the imagination. So when we look at records, we look at guilties like this has in Senate Bill 37, this most likely is not a first-time offender. So when we believe in second chances, we are giving most defendants a second chance by giving them probation before judgment the first time. So shielding, we say, is the answer to that. More importantly, we believe in second chances through probation that can be expunged. We believe in second chances through suspended sentences. But if somebody gets a guilty the first time, it means they've either violated their probation or the crime is more horrific than what's written down on paper. Most people get that probation before judgment. So we look at second chances. We are giving people first, second, and sometimes third chances in Maryland. So second chance is a good thing. And the way to do it is by shielding it from anybody who may look at it online. So for those reasons, we are asking for an unfavorable report as to Senate Bill 37. I'm happy to answer any questions.
Questions? Seeing none, thank you very much. That concludes the testimony on Senate Bill number 37. Thank you very much for that. We're now going to go to Senator Sidnor's bill. Senate Bill 293 is first. Senator Sidnor, please.
Good evening, Mr. Chair, Mr. Vice Chair, and committee. Senate Bill 293 is a very simple bill. I know you've heard that before. It was presented by our former Secretary of Department of Public Safety and Corrections. He and I were at a meeting, and he had talked about just the use of really some outdated terms, and in this case, it was the term inmate. What he had suggested, and what this bill does, is it essentially eliminates the use of the term inmate and replaces it with the term incarcerated individual. And there, I believe it, you had my written testimony about the other reasons. New York has done this as, and we just thought this was the right thing to do. So that ends my testimony, asking for a favorable.
Questions? Delegate Kaufman.
I'm sorry, I know the hour is late, but I do have a question for Senator Sidnor, because this is not my area of expertise. Why do you feel, Senator, that incarcerated individual is a better term? Could you just elaborate on why you're proposing we make this change?
You know, it's, and I was explaining this to one of my colleagues, many of us were raised talking about, when we've been talking about slavery, we called people who were enslaved slaves, when in fact slaves, they were not slaves, they were enslaved. There was a state, it was something that happened to them. These people, they're not inmate, they are incarcerated. They're incarcerated individuals. And I mean, it's just that simple. It's something that, because of the result of whatever decisions that they made, they're incarcerated.
Well, I thank you for that, Senator, because at first blush, I thank you for that education, because at first blush, those two words just seem like synonyms to me. So thank you very much.
You're welcome.
Any further questions, understanding that the Judicial Proceedings Committee is waiting to have a voting session? Delegate Tomlinson.
I will skip on that question.
My man.
All right. Thank you very much. That concludes the testimony for Senate Bill 293. We'll go now to Senate Bill 40. There are allegedly witnesses who also wish to testify. The words "me" and "to" might be very helpful this afternoon, but thank you very much. Senator Sidnor, go ahead.
All right, thank you very much. For those of you who served on this committee, you've seen this bill before. For those of you who haven't, let me give a brief introduction to you. Back in 2015, when we passed legislation to allow the use of body cameras to be worn by law enforcement officers, we had created a task force to kind of look at the issue and try to look at a variety of issues, whether it was storage, whether it was redaction. There was a number of issues that were looked at. One of the recommendations that came out of it was in dealing with the redaction or the release of certain body camera footage. What this bill does is it creates 5 different categories of when body camera footage would not be released to the general public. If you have a nexus to the video footage, say if it's something that happened to a significant other, to yourself, or whatever, you would certainly have the right under this legislation to get the footage. But if you were a victim of, let's say, domestic violence, or in that type of encounter, if you were a law enforcement officer who was shot and killed, your family would have access to it. The bill was amended by my committee to include some other incidents which were initially, I think when I introduced, were a part of it, which is, let's say that you were stopped, but not necessarily arrested. We had included those types of scenarios, which I believe are in Romans 5, if I'm not mistaken, because there are times when things happen to you, and the thought was, if you're encountering law enforcement officers, you may not necessarily, if you weren't arrested, you may not necessarily want that video out there for the public to see. You may have access to it under the legislation, but again, it was not something that we wanted generally out in the public. So with that, I rest and hand it over to our witness.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 40. Although I heed the chairman's comment, let me just say that Senate Bill 40 protects the privacy of victims. It does not change civil discovery. It does not change rules permitting access to footage introduced in evidence in court. It does not limit the ability of a victim to see the footage for any reason whatsoever, including holding law enforcement accountable. It does not prohibit alleged assailants from viewing the footage, although it does prohibit them from copying it. And so the victim would then be notified also that the assailant viewed that so they could do safety planning. If you had just been raped, you went to the door, you were disheveled, maybe this is not your best moment. If your child had been abused, maybe this is not your best moment. These are things that should be private. You should control that body camera footage. We do have cases where this has been an issue, and I'm happy to talk to anyone about those at another time. For those reasons, the Maryland Coalition Against Sexual Assault urges a favorable report on Senate Bill 40.
Any quick questions for the panel? Delegate Conaway.
Mr. Chairman, thank you, Delegate and witness, for coming. Senator, I'm sorry. I'm so used to seeing you on the other side. So is there any change in the footage that the news media would be able to get?
The news media, yes, it would not be available to the public, but again, let's say you were an individual that was exempted under here. If you wanted to put it into the news media, you could actually do that.
Right.
But the idea is there's some video footage that's out that you just don't want out there.
But there's some investigative reporting that's done by the news media that they get video now and put together what their story is going to be. Is that right?
I don't necessarily know if the media would be interested in the types of videos that we're trying to say shouldn't be put out into the public. Generally speaking, if you're someone if you were a victim of some type of police brutality, the video is going to be released. This does not prevent that type of video.
Okay, you could release it, or your attorney could release it.
Absolutely.
All right, thank you very much.
You're welcome.
Any further quick questions? Delegate Crutchfield.
Hello, Senator. How are you doing?
I'm doing well.
Good. And Ms. Jordan, as always. I just wanted to understand, what's the process going to be in order for a person that requests, public information? What is the process that person would go through so that, if they actually apply or want the information, what happens next? So just an individual just requesting information, can you just tell us what that process looks like?
Yeah, normally they would get that footage. It's a public record, so it's like any other public record that's available to the public. This bill would make it a shall deny. So if the county, for example, had identified that something involved the listed crimes, child abuse, sexual assault, domestic violence, then they would deny access to that. If you were the victim yourself, you would then you would be able to say, as part of your request, I am the victim of this. If you were otherwise depicted in the images, you also would be able to say, I fall under one of these exceptions. One of the things about this bill is that it also requires kind of a work group that brings people together to flesh out some of that. So I expect that a lot of those details you might be interested in are going to be fleshed out in a regulatory guidelines process that includes representatives of victims group as well as others who are interested.
Okay, thank you.
Delegate Embry.
There's a section that says a custodian shall deny inspection regardless of a subsequent action taken by law enforcement or court. I just wondered what that was aimed at. What subsequent action was contemplated? And I'm sorry, that's page 6, line 7.
So my interpretation of that, keeping in mind that this was written, I believe, in 2015, is that if law enforcement or the court did something regarding the body camera footage. They took an action, they arrested someone, there were court actions, that the Public Information Act would not be the avenue to obtain that information. It would be civil discovery, it would be criminal discovery, all of that is untouched, but really this is just inside that box of the PIA requests.
Thank you.
And if I may say, I think MACO is also here, so the legislation was initially put forth by them. They could also speak to that
Thank you.
particular
Thank you,
section.
Senator.
Further questions? Delegate Conway.
Problem with the release of the body camera footage that makes you bring this bill, that we're going to change the rules?
You know, that's not an easy question to answer. I think that there's been an issue on the other side, I believe, in terms of release, but not with this. Miss Jordan, I know she's had clients who have had issues that I think she could speak to.
Yeah, thank you for that question, Delegate Conway. We do have one case in particular that the Women's Law Center testimony describes in greater detail, where a victim of domestic violence, her husband obtained footage of her through the body camera, just through a public information request, posted it on social media. She, at this point, this has happened, I believe, a couple of times, she's terrified and will not call the police anymore. So this process has really deprived her of any access to calling law enforcement, because she's afraid that if she calls law enforcement, whatever happens is then going to be posted on social media, edited, misrepresented, all of the things that an abusive person would do.
And so that's one case in 9 years, basically?
No, I believe there are other cases as
Several.
well, but that one I know is in your record. I believe it's in the Women's Law Center testimony, so she's got some additional information there.
Okay, thank you very much.
Further questions? Seeing none, thank you very much. That concludes the testimony for Senate Bill 40. We're going to go now to Senator Muse, Senate Bill 507, please. And I believe it is just Senator Muse.
Yes, and just,
That's, wait, I'm sorry, are there more witnesses for Senate Bill 40?
Just the two, the others are here just in case you have questions.
Oh, wait, okay, I'm sorry, I need clarification. Whose bill is Senator Sidnor's bill done? Are there more people to testify on Senator Sidnor's bill?
MACO is here.
Oh, I'm sorry.
As well as
Okay, I thought I was getting all of them all at once. We're not done with Senator Sidnor's bill. We'll get Senator Bill 40. I'm sorry, Senator Muse. Let me finish
No
this,
problem.
and then we'll do that. Whoever would like to go first for 2 minutes.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Melanie Shapiro with the Maryland Network Against Domestic Violence, here in support of Senate Bill 40. I endorse all of the testimony already provided by Ms. Jordan as well as Senator Sidnor. I would just add that this policy to prohibit the release of body-worn camera footage of victims is consistent with the policy of the Battered Women's Justice Project, the National Network to End Domestic Violence, the International Association of Chiefs of Police, as well as I would read from what the ACLU says regarding body-worn cameras. The National ACLU, they say, our view is that for privacy reasons, the majority of body camera video should not be subject to public release. For all those reasons, we urge a favorable report on Senate Bill 40.
Thank you, Chair. Thank you to members of the committee for having me here today. My name is Sarah Sample, and I am here on behalf of the Maryland Association of Counties. We are here in support of Senate Bill 40. Thank you, of course, to Senator Sidnor for your persistence with this legislation. As a government, Maryland has agreed to roll out hundreds of thousands of cameras that are going to collect millions of hours, multiple millions of hours of footage of the public, and especially the vulnerable public. And this is a new technology, and we believe that we owe it to the public to make sure that we're careful and thoughtful about the way that this is rolled out. The first thing I want to point out is that the Senate has passed this unanimously multiple years. So they have given a stamp of approval that this is a good bill, and we're hoping we can get the same from this committee as well. In terms of the mandatory denials and the shall deny language, this language exists in current law in 6 different areas in the code that we have cited in our testimony. But that is specifically for written documents, all right? And so the new element here is that this is new technology that has to do with the cameras, and so we're trying to have some guardrails that are established with this being a completely different type of a record. The shall deny language does multiple things. Most importantly, it gives us the ability to streamline the misconduct cases. There have been instances in other states where one broad request that's not related to any incident or allegation can dwarf, in one instance, it dwarfed the annual operating budget of the redacting group with one single request. And so this bill would get some of those requests that don't have anything to do with the intent of police reform. They would get them out of the way so that we can achieve the intent of police reform and accountability with great speed, because that's going to establish the trust and accountability that we want to see, I think, with legislation like this. The other thing I would say is the shall deny, it protects the very unique type of victim footage that you're going to get from some of these cameras. So once you're inside that house, the amount of things that you have to eliminate are really overwhelming. You know, it could be something like the window that your child sleeps under is in the background. It could be something like a diploma on the wall. It's an innumerable number of things that would have to be taken out. And we've never had that kind of risk available in, a public information request. The other thing I would say, too, and I think
Very briefly.
Yep. The other thing I would say is that there are other instances in the state where the ACLU has said, similar to what my counterpart here said, is that inconsequential footage should not even be kept after about 6 to 8 months. You should just delete it. We're not even saying that. We're saying if you want to try to go through the appeals process, which is a very good process that we have in Maryland, if we still have that footage, then you can go ahead and get it, as long as we have it. So in closing, I would just like to say that we really respect and appreciate Senator Sidner's persistence on this.
We all do. Thank you very much.
And we think
Are there questions for this panel, please? All right. Thank you very much. Anybody else to testify on Senate Bill 40? Seeing none, that concludes the testimony on Senate Bill 40. We're going to go to Senator Muse again, Senate Bill 507. Senator Muse has 2 other people coming up to testify with him, I believe.
Yes, Mr. Chairman, we
Lisa
do.
Jordan.
And
3 more people to testify.
Yes, pretty much for support. Good afternoon, good evening, good night, I don't know which it is. But Mr. Chairman, Vice Chairman, and members of the House Judiciary Committee, I know we're down to less than a week, but this bill did not have a full hearing on the House side, but it is such an important bill that today, when you hear Mr. Troy Turner's story about what happened to his children, I do think as parents and grandparents, aunts, uncles, godparents, etc., we also would want justice for our loved ones. We're limited to the number of panelists that we have, so I just have 2 today. Tracy Varder, who's the Chief Assistant State's Attorney in the Mental Health Court, and Troy Turner, who is also a victim that I'll describe briefly in my testimony. I want to acknowledge our support from the Maryland Crime Victims Resource Center with Mr. Kirk Wolfgang and Detective Jeffrey Gray, who were here earlier but had to leave, and Lisa Jordan, who is also in support of SB 507. So what does this bill do? This bill, in 2019, it was SB 242. It passed this committee in the full House with no opposition, but it did not make it out of the conference committee in time to beat the clock. And so since then, we've amended this legislation, and so as amended, Senate Bill 507, which is what is before you today, would extend the amount of time for which the court can dismiss the charge of a defendant who is incompetent to stand trial and who is charged with first-degree murder or sexual assault from 5 years to a reasonable time of 10 years. This legislation would allow the actual victim or the victim's representatives to petition the court to extend the time for dismissal of certain charges against a defendant who was initially found incompetent to stand trial. So, friends, SB 507 aims to fix an issue in the statute, and it helps to give the victim of a crime a voice, instead of the state's attorney being the only person allowed to request an extension. And I'll close with why this is important. This legislation is important because of the victims, like my panelist, Troy Turner, who must have a voice. SB 507 is important because the crime was committed against his family and not the court system. And I think once you hear his story, you will understand. In addition, our state's attorneys across the state overall work to do their best. But sometimes when cases are 5 years old, they are off the list of importance or off the radar. However, it will never leave the hearts and minds of the victims of the loved ones. And so SB 507 gives someone a voice. And so for that reason, I urge a favorable report. And I'll ask Mr. Troy if he would go first. Thank you, Mr. Chairman.
I was going to let her go.
Okay, yes.
Thank you. Good evening. I'm Tracy Varder from the Baltimore City State's Attorney's Office. Senate Bill 507 is necessary to protect public safety, but it also continues to protect the rights of defendants with disabilities. In 2006, there were various public interest groups, including the Office of the Public Defender and the Maryland Disability Law Center. They participated in long discussions and compromise, which resulted in the amendment to Criminal Procedure 3-107. This included that incompetent defendants charged with murder would have their charges dismissed after 10 years. Then in 2012, after the repeal of the death penalty, the term capital case was removed from all statutes, and it inadvertently reduced the time from 10 years to 5 years for individuals charged with murder. The committee notes show that there was no discussion of this change, no discussion of consequences of doing so. So this 10-year provision needs to be reinstated for the following reasons. First of all, currently, Criminal Procedure 3-107 allows dangerous defendants to walk free. If an incompetent defendant has a mental illness and their charges are dismissed, they may, under certain circumstances, be civilly committed. But if you have an incompetent defendant who has an intellectual disability, he can never be civilly committed, but instead offered services that he is free to refuse. Last year, we had a defendant with a mild intellectual disability was charged with the brutal murder of his girlfriend. At the 5-year mark, the state filed for extraordinary cause to have his charges extended, but because of the impossible high standard set forth in the Ray case, the petition was denied, his charges were dismissed, he refused services, and despite testimony about how dangerous this individual was, he is now walking free in the community. We're in the process of recharging him, but we don't know where he is, and our biggest concern is we're not going to find him until he kills or hurts somebody else again. May I have about 15 more seconds? Second reason, 10 years will allow more time for dangerous defendants to receive treatment and become competent. Thirdly, this bill protects the defendant's rights that the 2006 work groups were concerned about. Importantly, the judge still retains the right to dismiss any charges at any time the court believes is unjust, and this only applies to dangerous defendants. So for these reasons, we are asking for a favorable report, and thank you to Senator Hughes for your work on this. Thank you.
Thank you. I actually wanted her to go first because I knew she would say some of the technical stuff, so I could keep mine below the 2 minutes. My name is Troy Turner. I want to thank you guys for hearing me out first. I'm the father of 3 children. 2 of them were murdered by their mother at ages 2 and 3. She's indicted on their murder. Because of the changes when the death penalty was repealed, she is actually now on a civil commitment, and I think it's important to say this. She was civilly committed before she murdered my kids, and because of the low standard to keep someone on that, she was let out. And then one by one, she took my kids by age, youngest to oldest at age 2, age 3, and then my 5-year-old, thank God she was stopped before she got him. He's still a minor, and I am terrified that she's going to get out and come after him. Like I said, she's under a civil commitment, so that could be at any point in time. We just want to fix what was broken by accident. We've spoken to people who were in the legislature. We've spoken to legislative aides. They said this was, as she spoke of, it was never spoken of. It wasn't thought about. So what happened was the 10 years got pulled out. It was put to 5. And quite frankly, if someone steals a TV set and it's a felony, if it's a $1,500 TV or you murder my 2 children, you're under the same bar right now. It's broken. It's not right. There's something wrong, and I'm asking you guys to fix it. I'll be very honest with you. It's not easy for me to come here and relive this. I've been doing it over the past few years. I've been here several times. Please do not make me come back again and do this. Please fix this while you can. It needs to be fixed now. I had a whole bunch of stuff here, but quite frankly, there's really not much else to say. I'm just begging you guys to fix this for me and my family and for everyone else out there.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of this bill. Thank you, Senator Muse. Thank you, Delegate Williams. This was your bill last year, and we appreciate your support for that. For the reasons stated by the witnesses prior to me, the Maryland Coalition Against Sexual Assault says, me too. I also wanted to say to the committee, this is my last hearing of the session. We bring some of the most difficult issues in front of this committee, and you have all listened to them with kindness, with open minds, and we very much appreciate everything that you do. This is hard work, and we appreciate it. Thank you.
Chair, thank you very much for coming to testify. And again, as Delegate Muse said to the previous witness that you heard testify, I'm so sorry that that things have failed you here in our system. But I think this is for one of the attorneys, I guess, to answer this question. Just if somebody's going to be released, I guess by operation of law, they just can't hold them any longer because the charges are no longer going to be no longer ripe, I guess, after 5 years. So if we don't change it to 10 years, is it possible to have a facility require the person to continue to be retained civilly, or it's not possible to have them recommitted if there's no charges? I'm trying to.
So the way it works, when you have a defendant who is incompetent to stand trial, and at this time, after 5 years, their charges are dismissed, the statute requires if they have a mental illness, and there's 5 criteria, they can be civilly committed. I do want to point out, though, that the standard for dangerousness that the court finds dangerous, and then once they are civilly committed, that threshold is much lower for dangerousness. But at that point, it is up to the hospital to determine when they're released, and the court loses all oversight. The problem is worse. When you have a defendant that has an intellectual disability, what the statute says is that if the charges are dismissed and the court finds this defendant is dangerous, that defendant is then referred to the Developmental Disabilities Administration for a 21-day hearing. Once they get to DDA, the 3 things DDA looks at is whether they have a disability, what services they are appropriate for, and what's the least restrictive. Even though the court has found them dangerous, dangerousness stops. They don't even look at dangerousness, and even if they did, there's nothing they can do because they cannot order this person into their services. They offer services, and the person can decline, and that's what happened in this horrific case I had last year. The minute his charges were dismissed, he packed his bags and left. And like I said, the testimony about how dangerous he was, I will say I spoke with the judge afterwards, and she felt her hands were tied by the Ray decision. She lost sleep over her ruling that day. And when we have law where the judge is losing sleep because she has had to let this extremely dangerous person out, that needs to be changed. So that's why we're starting with this today, hoping that we can at least get the statute back to the 10 years what it was before the repeal of the death penalty.
That's very helpful. Thank you very much.
May I speak on something really quick? You asked about civil commitment. The mother of my children who killed the 2 children, she was civilly committed. She was released 30 days after the original civil commitment. She did some things where I had reported it to her day program, then was put back in, then re-released before killing my children. And now, currently, through contact with people, she is on a step-down program to be released. The civil commitment, the bar is so low, it's not designed for what we're using it for.
Delegate Kaufman.
But this is important because people with intellectual disabilities have been invoked several times by the Assistant State's Attorney from Baltimore County, Baltimore City. Sorry, I was thinking Delegate Cardin there. My question is, Senator Muse, does the Maryland Disability Law Center, the Disability Rights Maryland, they changed their name, or the Maryland DD Council, have a position on your bill? Have you reached out to the disability groups about this?
They were there for the hearing, and they do have testimony on record, yes. and that can be provided from the.
So they are in support of your legislation?
At least one of them. I don't remember anyone being against it. It did not, it came out of our committee, no one with no opposition to the testimony that day.
Okay, if your staff could email me that testimony, that'd be great.
Absolutely. Thank you. Yes.
Any further questions? Delegate Munoz.
Thank you, Mr. Chair. Thank you to the sponsor for bringing this important legislation. I'm sorry you've had to do it more than once. And, sir, thank you for coming today to testify before us. It's incredibly difficult, and like Delegate Cardin said, it's incredibly powerful. And we see the two beautiful babies on your shirt. And I've seen tears drop in this committee while you were speaking, and sometimes that's what it takes. And I promise you, at least I'll do everything I can in the next 7 days to get this passed so you don't ever have to come back and tell your story again, and we can protect your third child. So thank you.
Thank you.
So, Mr. Chairman, I thank you very much. I urge a favorable report. I know you all get a number of emotionally draining issues because we get them as your sister committee. I hope that you can give us a favorable report. Thank you, and don't be here all night.
That concludes the testimony for Senate Bill 507. Thank you. See Senator Bailey. We go to Senator Bailey right now for Senate Bill 69. Then Senator McKay after that. Then Senator Watson. Then I think we have a representative from Senator Carter's office, and you're there. Okay, that's fine. Senator Bailey, please, for Senate Bill 69.
Thank you, Mr. Chairman and distinguished members of the committee. Senator Jack Bailey, representing St. Mary's and Calvert County, District 29, for the record. Senate Bill 69 is identical to House Bill 682, sponsored by Delegate Valentine, which you heard earlier this session. I'm going to be brief. This bill would require law enforcement agencies to maintain a record of positive community feedback for all law enforcement officers within the agency. This bill would direct the Maryland Police Training and Standards Commission to develop a uniform process to collect this feedback from members of the public, and it would ensure that these records are available for public inspection in accordance with the Maryland Public Information Act. This is a very simple concept. If a citizen takes the time to contact the police department, then whatever they say, whether it be positive or negative, should be received and recorded by that agency. It isn't done uniformly across the board that way right now. I've heard police supervisors, when they're talking about this issue with police positive feedback, they say those officers get the feedback. They get it in the form of their paycheck every 2 weeks. I had one of the departments in Maryland keep records for their first 100 calls. 60 were negative, but 40 were positive community feedback. They're not recorded anywhere. I respectfully request a favorable report on Senate Bill 69. You can see my detailed testimony. Thank you for your consideration, and I would stand for any questions.
Any questions for Senator Bailey? Seeing none, thank you very much. That concludes the testimony for Senate Bill 69. Senator McKay now for Senate Bill 277, please.
Thank you, Mr. Chair. I need to get over to JPR so I can vote on some judicial bills. So 5 different things. Senate Bill 277, Sheriff Sales Notice Procedures. You've originally heard this already in your committee, House Bill 729. As amended, it fixes all the opposition to the bill. It passed the Senate 45-0. Therefore, I recommend favorable amendment report of Senate Bill 277. And please let me go vote.
Does anyone have any deep and insightful and long questions for Senator McCray or McKay? Whatever, fine. Sorry. Thank you very much. Seeing none, that concludes the testimony to Senate Bill 277. And for those people watching in the Judicial Proceedings Committee, thank you very much for your patience. We did the best we could. And so now, Senator Carter's representative is here. We'll go there first because we also have a representative from Senator Watson as the Prince George's County person. But go ahead. That's a different bill. Senate Bill 769, please.
Yes, good evening, Mr. Chair, Vice Chair, members of the committee. Charles Byrd, Chief of Staff on behalf of Senator Carter. Regarding Senate Bill 769, this is a local Baltimore City bill. It will allow for property to be transferred to heirs prior to the liens being paid. As you're probably all aware, typically all liens need to be cleared before property can transfer. In a case where their heirs can inherit the property, but a lot of times they still need to work through some type of payment arrangements, and Senate Bill 769 will permit that. It would alleviate the immediate need to find funding to clear liens in order to transfer property to heirs, which is now a major obstacle for lower-income residents in the city to continue property ownership and apply for assistance programs and build generational wealth. Currently, there are a number of programs and pro bono legal services for low-income residents and potential homeowners. However, there is nothing to deal with a situation like this, and that is in a situation where someone inherits property from a loved one and their liens on the property is preventing them from having it transferred in their name, and they lack immediate funds to clear the liens. So this would allow them to go to the additional step in building generational wealth, and they would be allowed to work out a payment arrangement after the transfer in order to have the property in their name. So it will provide support to struggling property occupants and provide ways to connect them to appropriate home ownership preservation resources that are available to the community. And with that, we request a favorable report. I'd be glad to entertain any questions.
Any questions? Delegate Conaway.
Thank you for coming in and presenting the bill. So if the lien is passed on to the people who are going to inherit the property, then the people who are the generators of the lien don't have any say on whether or not they will continue to honor that lien or whether or not they want to be paid?
Okay, maybe I misspoke. This is generally pertaining to tax liens and assessments by the city.
By the city. So therefore, the city would just pass on the tax lien to the person who's going to inherit the property?
That is correct, and then that person would make arrangements for
and what
payment
agency
plan.
in the city would do this?
I'm sorry?
What agency in the city would do that? Is that would be land records, or would that be the tax division?
I'm not 100% sure.
Would that come through the
It's
Register of Wills office?
Which one? But this is at the request of the Baltimore City Administration.
Yeah, I understand. Would that come under the Register of Wills office? Do you know?
I'm sorry?
Would this come under the Register of Wills office? Do you know?
I don't think so. It would once the property is transferred, then the payment arrangement for the tax lien will be worked out through the city administration.
Be through the Office of Finance, probably, not through the Register of Wills office, because there's a lien on the property, and that would be set, I think, in the Finance office as opposed to there.
Yeah.
I think. Sorry to intervene, but
Thank you, Mr. Chairman.
I think I get to the background maybe of where the question is, and perhaps a concern about a conflict, maybe?
Yes, sir. Yes,
All
sir.
right, that's fine. So if we have to work on that, we can work on that.
Thank you.
Any further questions? Seeing none, thank you very much. That concludes the testimony for Senate Bill 769. And the last one, Senate Bill 411. Here he is from Senator Watson's office. This has to do for the judges of the Orphans Court. All right, go ahead, tell us what the bill does. Thank you.
Good evening. I'm here on behalf of Senator Watson. I serve as his legislative director. Senator Watson would like to seek an amendment to the Estates and Trusts article of the Maryland Code regarding salaries for the Orphans Court judges in Prince George's County, authorizing the Prince George's County Executive and County Council to determine their compensation. As the code currently reads, their compensation is set at a specific dollar amount. Before the county executive and the county council can implement a salary adjustment, they have to introduce a bill for the proposed adjustment so that the new compensation is accurately reflected in the code, which increases the work of this committee on a local issue. forgive me, the Senate committee. The amendment to the code will eliminate the necessity to have to introduce a bill before the body every time the Prince George's County Executive and County Council wishes to provide their orphans court judges with a modification to their salaries. Further, it has Prince George's County join the majority of local governments in Maryland who determine the salaries of their orphan courts bench. Currently, there are 12 other counties that operate in this fashion. This is the local bill, of course, and there's also a delegation letter in support. We urge a favorable committee report.
Thank you very much. You said there's a delegation letter from the House delegation as well, from the Senate delegation, but there hasn't been a letter from the House delegation yet?
Yes. Or no, I'm sorry.
There's no House bill. So, the
Right.
House delegation sent a letter? I'm sorry, I'm being a little obtuse.
Yeah, sorry.
If I can chime in for
Sure.
the Senate, the Prince George's County Senate delegation has sent a letter of support. There is no House cross-file on this particular bill, Mr. Chair, so the House delegation has not weighed in at all on this bill because there is no House bill. It was only just the Senate bill from the Senate delegation.
Okay, so will we see a House delegation letter in our future, or?
I'm not aware of a letter that is forthcoming. We are not meeting again the rest of this session, and I am not aware of us being requested for a letter.
Oh, okay. That's some interesting drama to add to the end of the bill hearing. Does anybody have any questions? Why is not allowed at this point. If you want why, go talk to Delegate Williams later. All right. Seeing no further questions, we do thank you very much for coming over. That concludes the testimony for Senate Bill 411. Members of the committee, you have two options. One, some people would like to go and have dinner at the Speakers Society, and they would like to go over at least for a little period of time and do that. We can do one of two things. We can either get back going again in 15 minutes with our voting session, or we can come back at 7. So it's either a choice of 6:40 or 7 o'clock. What's your pleasure? All in favor of 6:40, raise your hands. 1, 2, 3, 4, 5, 6, a lot. All right. We're coming back at 6:40. Thank you very much for a voting session.